So, when I said first that Kennedy Krieger is not just a hospital, this is an example. So, Maureen Van Stone is an attorney, and she's the founding director of a program we have here called Project HEAL, which is really about advocacy and law and advocating for our patients' disabilities. And she's also the associate director for the Maryland Center for Developmental Disabilities. So, I think this is very helpful what we're going to hear in the next half an hour. Thank you for being here.
So good afternoon. Thank you for having me. I appreciate the opportunity to speak with you this afternoon. You do have copies of all of the slides in your materials. You will also receive electronic copies of the slides. I want to warn you, I have included a lot of content. I received lots of questions in advance of the presentation, and so I wanted to try to sort of cover the spectrum from preschool age through adulthood. And I'm going to have to move quickly because I want to cover as much of the content as I can. I also did bring my brochures that I can pass around. And if anyone has questions following the presentation or in the future, feel free to email me directly. As Dr. Fatimi mentioned, I direct Project HEAL, which stands for Health, Education, Advocacy and Law. And in our program, attorneys provide advocacy and legal services for low and moderate income families and children with intellectual and developmental disabilities who receive clinical services here at Kennedy Krieger. I founded this program after graduating from law school in the fall of 2005. Our goal is to resolve civil legal issues that we believe affect health and family stability. We sort of capture the types of legal services that we provide in three buckets. One is representation, so that is a family obtaining me or one of my staff attorneys as their attorney to represent them in a civil legal dispute. About 95% of my cases are special education disputes. We do some discipline appeals and supplemental security income appeals and simple family law matters for non-custodial parents who are raising a child. We provide limited representation, which we sort of categorize as an hour or less of service to our parents and families. It could include brief advice, document review, information and resources, pro bono referrals to one of our law firm partners. We currently have 4 law firms who partner with our program and provide pro bono legal services. We also provide case consultations to our faculty, staff, and trainees here at the Institute, and that includes brief advice, document review, information and resources, and referrals for our intake line. In terms of all referrals for my services, all our faculty and staff and trainees can make referrals directly to our program via email, telephone, or an internal referral form. Families may also self-refer. We have lots of families who chit-chat in the lobby and will indicate that they've been served by Project HEAL and refer other families to us. In all of our representation matters, the clients must be patients here at Kennedy Krieger. They must have ripe legal issues that require the intervention of an attorney, and they pay a sliding scale for up to 10 hours of our legal services. Some of the common legal issues, and we'll sort of talk about this throughout the presentation, that we see are school system denying a child with a qualifying disability an IEP, school system failing to provide accommodations, modifications, programmatic supports, supplementary aids and services that the child is legally entitled to, the school system failing to consider or implement recommendations made by our clinicians here at Kennedy Krieger, the IEP is failing to meet the unique needs of the child, or the school program or placement is not meeting the unique needs of the child. And about 60% of our cases is a placement-related issue. So the placement is either not restrictive enough or too restrictive for the child. There were a number of questions I received in advance that wanted to turn on special education rights and responsibilities for families. And I wanted to highlight for you the relevant laws that apply. The Individuals with Disabilities Education Act applies to elementary and secondary education. Section 504 of the Rehabilitation Act of 1973 is just basically an anti-discrimination statute indicating that you can't discriminate against a student on the basis of their disability. It applies in elementary, secondary education, and post-secondary education. In Maryland, we have an education code, the Code of Maryland Regulations, which applies in elementary and secondary education. And then lastly, we have the Americans with Disabilities Act of 1990 that applies to elementary, secondary education, and post-secondary education. Under the Individuals with Disabilities Education Act, children with disabilities ages birth through 21 have a right to access a free, appropriate public education. For birth through age 2, they access those services through an individualized family service plan, and from 3 to 21 years of age through an individualized education program. The evaluation process is a multi-step process. It starts with a referral, and the referral determines whether a student needs an evaluation for special education and related services. It's important to note that you as parents can make the referral, the child's pediatrician, any outside treating physicians can make the referral to the IEP team at the student's school. Or the child find office in the jurisdiction where you live. Children, are usually referred by parents, teachers, or pediatricians. Things to note, the referral should be made in writing. The referral should be dated because it's triggering timeline implementations, and you as parents should keep copies of the referral for your records. We then move on to who is deciding whether or not this child is going to need help. It's going to be a multidisciplinary team approach, including parents, a general educator, a special educator, service providers, a school administrator, the student if appropriate, and in general, we would like to have someone from the district, so the local school system or the local educational agency should have a seat at the table. The evaluation process includes meeting with the team and reviewing existing data, determining if formal assessments are needed. The completion of the assessments must be done within 60 days of you as a parent providing written consent, and there must be a follow-up meeting with the team to review the assessments and discuss eligibility for special education and related services under IDEA. A parent must provide written consent to the assessments. They must be in all areas of suspected disability. They must be performed or explained by a professional. One thing to note is the law does not require that the person who examined the child is actually the person that reviews the report with the parent. So one school psychologist may actually do the evaluation, and they may send another school psychologist to the meeting to review the results. That is okay under federal and state law. The only thing that I would suggest to you is if you have questions for the actual evaluator, that you get that person's contact information so you can follow up with questions if the person presenting the report cannot adequately explain to you. The assessments from the local school system are to be provided to you at no cost, and if you disagree with the assessment results, you can request an independent evaluation, which means an evaluation done by someone else outside the school system, and the school system can agree to pay for it, or if they refuse, they must put their reason in writing, and then they will file for a due process hearing so that they can prove why their evaluation was appropriate for your child. Just because a child has a clinical diagnosis, sadly, does not mean that they automatically qualify for an IEP just because of his or her disability. And this is sometimes really difficult for parents to understand because clinical diagnoses do not directly align with federal law in terms of eligibility categories. So whether the child, because of his disability, needs special education and related services to make meaningful educational progress, and that's really the sort of crux of the discussion, and the child's disability must adversely impact his educational performance such that he or she is in need of special education and related services designed to meet their unique needs. So this is how we're making this eligibility determination. There are 14 eligibility categories under federal law. I assume that most of the patient population in this room would qualify under other health impairment. I sort of created this as a little tip for the evaluation process because this is a lot of information. It's complex. There are timelines associated with it. So my tips for you are to keep a copy of a letter requesting the evaluation and the consent for evaluation that you signed. Keep a calendar or timeline for the evaluation process for yourself. Do not rely on the school system to adhere to the timelines. Again, 60 days since you gave consent and 90 days after receiving the original written referral for the IEP to be developed. If the school system provides you with any parent rating scales to help your child become eligible for special ed and related services, you should certainly complete those rating scales timely and submit them to the school. Keep a copy of all assessments in binders. If you have outside evaluations from Kennedy Krieger or any other hospital, you may wish to share those with the IEP team for their consideration. Provide written consent to initiate services if you agree with what they're proposing, the IEP or the IFSP. And a qualified student with a disability may be reevaluated at least once every 3 years. And in some cases, school systems will not take that initiative to say, we're up for reevaluation, let's do this all over again. So I strongly encourage you, as your child's developing and progressing, for you to initiate those reevaluations. So what is special education? An eligible child with a disability has the right to a free, appropriate public education provided in a least restrictive environment. Special education is specially designed instruction to meet their unique needs and allow the student to access the general education curriculum. And it includes related services. Related services that I think this patient population may qualify for are transportation services to and from school, speech and language services, occupational therapy services, physical therapy services. But then other services are available include counseling, social work, psychological services, school health and nursing services in conjunction with a nursing care plan through the school. What is an IFSP? It is a document or a written plan that focuses on the child and family and the services that the family needs to help enhance their child's development. So a little bit of a distinction between the IFSP and the IEP. The IFSP is really including the family in the process, including the family in the discussion, focusing on the needs of the family, whereas the IEP is focusing on the needs of the student. IFSP services can be provided in the child's natural environment, the home, the Head Start, the daycare, or the preschool. An IFSP will include a child's present level of functioning and areas of need, family information including the parental concerns, results or outcomes expected to be achieved by the child and the family, and specific early intervention services that your child will receive and where and when those services will be delivered. An IEP is a much more complex document that describes the special ed and related services the child is entitled to. The IEP team must develop the IEP within 30 days of the evaluation meeting, and the school system must implement the IEP as soon as possible after the meeting. An IEP must be held at least once a year to review the child's progress and revise the IEP if necessary. And if a child is qualified, you are entitled under federal law to quarterly written progress reports on how your child is doing working towards the goals and objectives on their IEP. An IEP includes academic achievement and functional performance, so you're looking at the academics and functionally what's going on for the child in school. There are annual goals and short-term objectives. In Maryland, we have short-term objectives to meet these annual goals. Not all states do, so you need to check the regulations in the state where you live. The related services that are included on the IEP must include the type, the frequency, and the duration of the service, and supplementary aids and services, accommodations, modifications, and supports. Some tips for the IFSP or IEP development that I wanted to share is bring a partner, a friend, or a spouse to the IFSP or IEP meeting if you think it would be helpful. Some families choose to hire a lay advocate or an attorney for representation. That is a personal choice, and that was an issue that came up, I think, from your Facebook group. And, you know, that is a personal choice. It depends on the complexity of the case. It depends on the availability of advocates and attorneys in the area where you live. It depends on affordability. It depends if you are working really collaboratively with the school team, or if you feel like you are in a more adversarial relationship, or you feel like you've really truly reached an impasse. It might be a good idea to hire an advocate or an attorney. If you don't understand a recommendation, make sure you ask questions to the professional who's making the recommendation for your child. As Kylie said, you know your child best. I have so many parents that are really afraid to either ask a question because they don't want to appear that they don't know, or they are intimidated by the related service provider presenting the information. And I encourage them, just speak up, ask the questions. It's their job to answer them. Take notes during the meeting so that you can reference them later. Sure.
that you have this great document, everybody collaborated, it's put into place, but actually doing what's in the document and the accountability of when your kid's at school and you're not there monitoring, how is it best to make sure that what is written is actually what is happening?
So failure to implement will trigger additional rights that I will cover in a few slides. But the implementation piece is a challenging piece. You are not in the building every day. You cannot observe your child. Your child may or may not be able to communicate what's happening or what's not happening. Your child may or may not understand what they're entitled to on their IEP as they get older, and I'll cover that as well. You want to make sure that they do to the extent that they can. But the implementation piece is the hard part. And, you know, it's really difficult for me when I have families come and say, they're not doing this, they're not doing that, they're not doing that. And I have to say, how do you know? We have to figure out how to prove that they're not doing this. And that's a real challenge. If you wish to audio record the meeting, I suggest that you ask to record it in advance of the meeting. Be aware that providers use different descriptive categories for your child's performance on testing, average and below average. Take note of standardized age-based normative scores. In fact, I had a battle the other day in an IEP meeting about this, and I had to pull up the standard scores on my phone during the meeting. Request a break if you need it. There's no reason that you can't take a break. If you have a partner, a spouse, a friend with you, and you are feeling overwhelmed, just say, can I have a 2-minute break, and walk out into the hall. And try to remain calm. Again, sometimes it's easy and sometimes it's pretty difficult. You have the right to be notified at least 10 days in advance of the meeting. You can waive the right to a 10-day notice and proceed with a meeting if you choose. You can ask to reschedule. If parents receive 10 days notice but cannot attend on the date the meeting is scheduled, then ask that the meeting be rescheduled so you can actually attend. Again, as I mentioned, educational placement is the most litigated issue nationally. The IEP team determines where the student will receive their special education and related services. School systems must provide a variety of placement options, including the general education classroom, access to a resource room, more than half the day in a resource room, or public separate day school. If the school system cannot find an appropriate placement, then the school system must pay for the child to attend a private separate day school. And in Maryland, we refer to them as non-public special education facilities in our state, and we have a state-approved list of non-public schools. This, I won't go into detail. It's just taking you from the least restrictive environment under federal law to the most restrictive environment. In terms of extended school year services, this is really complicated. A lot of IEP teams don't do a good job of determining eligibility. They don't do a good job of explaining it to parents. So the IEP team must consider if the student's IEP has goals related to critical life skills, and then they have this multifaceted approach to looking at it. They'll look at regression and recruitment. They'll look at degree of progress towards mastery of goals, emerging life skills or breakthrough opportunities, interfering behaviors, the nature and severity of the disability, and special circumstances. The team must also determine if the student's ability to make progress during the school year is in jeopardy if he or she does not receive ESY services. A distinction and something that's really confusing to families who live in jurisdictions where they offer summer school. ESY is not summer school, okay? Summer school is offered to general education students and some special education students, but it's just a regular summer school program. Qualifying for ESY is looking specifically at the child's individualized goals and objectives on their IEP, selecting which ones are going to be worked on over summer, and working specifically to make progress on the goals and objectives on their IEP. So try not to use the term ESY and summer school interchangeably because they really mean two different things. Tips for ESY: if your child has an IEP, your child's team should hold a meeting before the end of the school year to determine eligibility for services. If they do not schedule a meeting, you should request one in writing. Request a meeting so that you have enough time to appeal the decision if they make a decision that you disagree with. And the IEP team should review eligibility for ESY each year. So just because you qualify one year does not automatically mean that the student is going to qualify the next year. In terms of transition planning is a requirement under IDEA. We have really good language in the law when it was reauthorized in 2004 about transition planning. It's a process that brings together students and their families with educators and other adult service providers to help plan and prepare students to leave school and enter post-secondary school environments such as adult day programs, employment, vocational schools, and college. The federal law states that all children with disabilities are entitled to transition services, also known as transition planning. These services are provided by the school to help students transition from high school to the adult world. In Maryland, we have 3 ways to exit the school system: earning a Maryland high school diploma, earning a certificate of program completion, or earning a GED. In our state, we have several post-secondary options, including adult day programs, employment, vocational programs, and college. The transition planning process helps prepare the student for their transition out of high school and into adulthood. In Maryland, we start transition planning at the age of 14. Under federal law, transition planning begins at the age of 16. So you will need to check with your state regulations to determine what year transition planning is required to start. Transition plans must be results-oriented. They must be based on the individual needs of the student. They must improve academic and functional skills and help transition out of high school. I did include goals for transition planning to get you thinking about the various areas, including academics, communication, social skills, occupational and vocational skills. And then I included a couple slides that take you through transition planning at certain ages and what should be happening in schools, government programs, and in terms of self-advocacy. So the first slide is for 16-year-olds, and the next is 17 to 21 in all of the same categories. In terms of resolving disputes, request an IEP meeting to discuss your concerns before you go to another level. You can file a free complaint with your State Department of Ed, and this is great because you have to be issued a letter of findings within 60 days. You can file for a mediation in writing, and the mediation must include an independent mediator, and both parties must agree to mediate. You can participate in a resolution session, which was a new component of the law in 2004, or you can file for a due process hearing. What you need to know about due process hearings are they are formal and expensive proceedings. Tips to resolve your disagreements: explain your concern to the team and why are you concerned, and give concrete examples. Touch base with your child service coordinator or IEP chairperson regularly so they're not surprised by your concern. Always participate in the IFSP or IEP meetings. Contact your Partners for Success program. And they're in all jurisdictions. I don't know why it says city schools. Or all states have a parent response unit for the state. In Maryland, it's called Parents Place for Maryland. Contact an attorney or advocate if you think you need help navigating. There were some questions, and we don't have time to go into this because this is a lecture on its own, about workplace disclosure of disability. So I did want to just touch on a few quick legal issues. There are legal protections for disclosure under the ADA, under the ADA Amendments Act of 2008, and under Section 504 of the Rehabilitation Act of 1973. Providing reasonable accommodations is required by federal law. There are problems with disclosure and confidentiality. There is one recent journal article that I recommend. Now, this journal article is focused on disclosure as it relates to high-functioning individuals with autism spectrum disorder, but the federal law that applies and the issues in terms of accommodations, problems with disclosure and confidentiality are all touched in this article in a really good way that I think applies across disabilities. So you can access that article through the link. In terms of resources, I put together, because I knew our audience was from a number of states and international, here are some national resources we have in the United States. The Council of Parent Attorneys is a large network of over 2,000 attorneys representing students with disabilities like myself, advocates, and parents. If you are not familiar with COPA, I strongly encourage you to go check out COPA on our website. Full disclosure, I'm the vice chair of the board of directors, but it is a fabulous, fabulous organization. IDA.gov, the National Council on Disability is producing a lot of really great publications and reports about your rights. National Disability Rights Network. Every state and U.S. territory has a protection and advocacy organization as required by federal law. They all feed into the parent organization known as the National Disability Rights Network. If you aren't familiar with the protection and advocacy organization in your state, then you may want to go on the National Disability Rights Network website and then click on your state and find out who your PNA is in the state where you live. And then lastly, my program is not unique. I am unique in Maryland. I'm the only medical legal partnership in our state, but there are hundreds of medical legal partnerships across the country. And so if you haven't accessed the National Center for Medical Legal Partnership website, you can go on the website, click on your state, and find out if there's a program like mine in the jurisdiction where you live. And amazingly, I finished on time. So this is my contact information. As I said, feel free to email me. I'll try to pop in and out over the course of today and tomorrow if anyone has questions.